How does bankruptcy affect your will or estate plan? Hi, I'm attorney Leroy Roberson back again, and I wanted to talk about this topic because I just recently made a video about inheritances. So I figured I want to make a video about how bankruptcy is going to affect your full estate plan. For example, if you're filing bankruptcy and you have an estate plan in place, so you have assets that you want to give to someone upon your death, or if something happens to you, bankruptcy will absolutely affect that depending on how you have it set up. So one thing that you want to remember is when you file bankruptcy, all the assets that you own become a part of the bankruptcy estate at the time that you file. So anything that you own, even if you have it in an estate plan, if you actually own that, the trustee can get access to that asset to pay off your creditors. And at the time of you passing or whatever happens, all of your creditors are going to get paid off before whatever else is left over is divvied up amongst your heirs or whoever's supposed to inherit those assets that are in your estate plan. So that's an important thing. So a lot of people, what they will do is they may transfer those assets to, whether it's into a trust that's not in your name, or transfer it, into another account that's not in your name, to try to avoid having this happen to them, having the trustee come in and take that asset to pay off the creditors. But one thing you want to make sure that you're watching out for is that a trustee can file a lawsuit against you for any fraudulent transfer, and the time that they have to file can be as long as 10 years. So you really have to be careful how you set this up, because if you set it up and the main reason that you're setting it up is to keep it out of the hands of your creditors because you know you're going to file bankruptcy, that's a situation that absolutely that fraudulent transfer likely is going to take place, and the trustee is going to be able to get that asset back and pay off your creditors. So you can meet with an estate planning attorney. If you do want to set up an estate plan, don't let the fact that you may be filing bankruptcy in the future prevent you from that, but just make sure that you set it up in a way and make sure that you have all of the paperwork. So you want to make sure you show that it's not a fraudulent transfer, because oftentimes you may want to set up an estate plan, transfer assets to different people for justified reasons, not just to avoid creditors through bankruptcy. So you want to make sure that you just have the proper paper trail, have it in the proper channels, and set up the right way to avoid this happening. Doesn't mean that a trustee won't try to come after that asset, but the more you have it documented to show that it isn't a fraudulent transfer and it is in fact a valid transfer of that asset, then you're in a better situation to not have that trustee be able to gain access to that asset to pay off your creditors. So if you have any other questions about this, feel free to contact me. It can get really detailed, so a good consult may be the way to go in this. And remember, all this is for Chapter 7. If you file for a Chapter 13 bankruptcy and you have estate plans, remember the trustees aren't looking to come after your assets, so you can enter into a Chapter 13 bankruptcy with ease of mind that they're not going to worry about what your estate plan has, because you're going to be paying those off. So if you have a good estate plan set up, then that's where, as opposed to doing a Chapter 7, a Chapter 13 may just be the easiest route anyway. So if you have any other questions, feel free to let me know and we can talk about it. If not, have a great day, guys, and I will see you on the next video. Thanks, guys.